Okay, good evening, ladies and gentlemen. Welcome to tonight's Committee of Adjustment meeting. This meeting is to consider applications for minor variance and consent held under the authority of the Planning Act of Ontario. The role of the committee is to review the proposals that are before it, consider the evidence provided, and make a decision based on the 4 tests established by the Planning Act. In order to conduct an effective and efficient hearing, we have adopted the following process. Tonight's meeting will be live streamed and available for future viewing on the town's live stream page at oakville.ca/live. People attending this committee meeting are to be courteous and respectful of the members of the committee, town staff, and others in attendance. We ask that you maintain your cellular phones on silent or at least or switched off at this time. All remarks and questions are to be directed to the chair. All persons wishing to address the committee are required to provide their name and address. A maximum of 5 minutes will be provided to all speakers. Any submissions beyond 5 minutes will be at the discretion of the chair. Any materials presented to the committee for viewing will remain the property of this committee. Persons seeking a deferral or withdrawal of an application will be invited to do so at the onset of the meeting, and if a request of a deferral is granted, it is the responsibility of the applicant to contact the Secretary-Treasurer regarding the scheduling of a new hearing date. At the request of the committee, the applicant may be asked to provide a brief presentation and answer questions that may arise. If the applicant has concerns with the recommendations and proposed conditions found within the staff report, this is the time to advise the committee. All persons who wish to support or oppose an application will then be given the opportunity to speak to the committee. In the interest of efficiency, groups sharing the same point of view are asked to select a spokesperson, and individual speakers are asked not to cover the same points as those who have already spoken. The applicant will then be given an opportunity to respond to comments made by interested parties and answer any additional questions from the committee. Discussions will then be closed and the matter will be taken into committee for a decision. Once the committee has made an oral decision, any person desiring a written copy must file with the Secretary-Treasurer a written request for notice of the decision. A green sheet is provided on the table at the back of the room for this purpose, and only those filing such a request will be given any subsequent notice of any appeal. Notice of the committee's decision will be mailed to the applicant and anyone who filed a written request no later than 10 days following the decision of minor variance and 15 days for consent applications. If you do not agree with the committee's decision, you may appeal the decision to the local planning appeal tribunal, and the last day to appeal will be noted on the decision. If no appeal is received within the prescribed time frame, the decision of the committee becomes final and binding, and the applicant and anyone who has received a copy of the decision will be notified through written correspondence. Thank you. We have no regrets this evening. Do I have any declaration of pecuniary interests? I see none. We have no consent applications. With that, we'll take the first matter on our agenda this evening, which is CAV 027 of 2020 at 62 Ennisclair Drive West. Good evening.
Good evening, Madam Chair, members of the committee. My name is Terry Martino, Grenweiss Architect and Associates at 341 Kerr Street in Oakville, and we are the agents for the owners, Mr. and Mrs. Bianchini, who are also in attendance tonight.
Okay, good evening, Mr. Martino. Who is here for application CAV 027 of 2020 at 62 Ennisclair Drive West? Okay. Okay, go ahead, Mr. Martino. We know this is in addition to the existing dwelling with the variances that you're requesting. Are there any questions or items of clarification of Mr. Martino at this time? Go ahead.
The existing 1.5-story detached stone garage will remain as is, or will it be renovated?
Through you, Madam Chair, it will remain as is.
And a follow-up, there's no running water in there?
Through you, Madam Chair, there is running water presently in the lower level as it is functions as a pool house, but on the second floor there is none.
Can you supply us with drawings for that garage, other than what's here?
Through you, Madam Chair, I'm not sure what the committee has, but these are the drawings of the existing coach house that was completed in 2008. So as you can see in the first floor, the ground floor plan of the existing coach house, there's the bathroom. And upstairs is a completely, upstairs is a completely open space for storage.
I'm sorry, could you please speak in, I couldn't hear you, I'm sorry.
I'm sorry, as you can see on the ground floor plan, there's an existing washroom. So
Okay.
there is obviously water to that. And the second floor of the existing accessory dwelling is one big open space.
Thank you.
Thank you, Madam Chair. Madam Chair, a two-part question. First for Mr. Martino and second for Mr. Hassan. So, Mr. Martino, just for clarity, it is your intent to merge these two properties together?
Through you, Madam Chair, yes, a deeming bylaw application has been submitted to the town. I think staff could speak to that as to whether timing, but in consultation with staff, we had to make a deeming bylaw application. As there are two lots in a plan of subdivision, the deeming bylaw will then effectively pull them out of the subdivision and make them one large lot.
Thank you. And Mr. Hassan, given that, would it not be appropriate for a fourth condition that the two properties merge on title? So without the properties merging on title, you're going to have a side yard issue with the bridge, are you not?
Yeah, through you, Madam Chair, that would be appropriate. Staff did discuss that, but noting that the intent was to proceed with the deeming bylaw post the decision of the Committee of Adjustment, staff felt that it wasn't warranted. But in this situation, that's a good point, and I don't feel there's an issue implying that condition.
And Mr. Martino?
Through you, Madam Chair, we would have no problems with that condition.
Thank you.
Did you get that?
Does anyone else have any other items of clarifications or questions for Mr. Martino at this time? Mr. Martino, I did start with the questions, but feel free to take us through whatever you need to take us through, and this is your time.
Well, thank you, Madam Chair. Just briefly, as I mentioned, the proposal seeks to add an addition to the existing residence, and the architecture, or at least the idea of the design, was to create a separate effect looking like a house, and you can see it here, so that it would be consistent with, first of all, the existing dwelling, but also the size and the scale of the other houses on the street. So effectively, from a streetscape perspective, it would look like a single house. It's not attached on the ground floor. It's attached simply by a link on the second floor. Furthermore, the streetscape is consistently treated with the pillars and the driveway entrances as the existing residence. I guess for committee's sake, my client circulated his neighbors with an email, as well as these drawings that you have before you in the rendering. I personally canvassed the neighborhood and had an opportunity to speak to a number of the residents who expressed no concerns. Obviously, they're not here tonight. There were 2 letters of support which I believe you have on file, and I'd be happy to answer any other questions that you may have.
Ms. Murray, you had signaled for a question?
Yeah, I do. Sorry, the drawing you put up, is that to be what 62 looks like, or 70?
70.
70.
I was just going to turn to the 62. Perhaps if we could zoom out slightly. Even more, possibly. Thank you. So as you can see, this is 62, the existing house. This is the proposed addition, north property. That is the rendering, obviously, of that. Again, the idea was to use same stone on the house, and obviously the construction of the house now in 2020 reflects the sort of architectural style of this period rather than the existing house that was built in 2008.
One more follow-up. So the idea is with the bridge, this is to become a single-family dwelling?
That is correct. It's an addition to the existing house. The architectural idea was to make it look like another house for the purposes of the streetscape and the massing, and the idea of having clear space on either side of the.
So what would be the total floor area then of the single-family dwelling once merged?
Through you, Madam Chair, the total residential floor area, would be 6,500 square feet, 605 meters square.
Madam Chair, I have a question for city staff.
Mr. Hassan, we have a question.
Mr. Hassan, if this lot was already merged and there was a variance asking for 6,500 square feet, would it be supported by city staff?
Yeah, through you, Madam Chair, we actually met with the applicant prior to the application being submitted, and as noted in the staff comments, the proposed addition was much closer to the existing dwelling on lot 62, and staff had reservations about that just for the fact that in the future, if the lot on number 70 were to be proposed to be conveyed, then there would be issues, again, with the siting of the building. That's why we felt that, as Mr. Martino had noted, separating the dwellings provided that spatial separation that's found within the area.
If I understand this correctly, so in the future, if there's any issues, then what, you would remove the bridge and they would be two separate homes that could be sold or conveyed
Well,
as such?
through you, Madam Chair, after the deeming bylaw is registered, the lots would be two as one, and then they would have to go through a consent process to formally subdivide the lots in the future.
Okay. And that is your intention, to keep them together unless it needs to be separated?
The intention is they'll always stay together as one lot, yes.
Okay.
I guess by way, if I could just further perhaps answer your question, as a result of this proposal, the existing, if you can understand, 62 Ennisclair presently has a lot coverage of 32% and a floor area of 36.18%. We went to Committee of Adjustment in 2008 to obtain those approvals. After the addition is put on, over the entire lot, the coverage actually goes down to 27.62%, so the amount of area built on the lot, and the residential floor area is at 37.61, which is in keeping with the sort of size and scale of the 62 lot previously. So the coverage goes down and the overall floor area goes up by 1%.
Thank you. Further question, Madam Chair, for the staff.
Okay, go ahead.
Question for the city staff. If this was one house, would it be the impression of the town staff that this would be in keeping with the character of the neighborhood?
Yeah, through you, Madam Chair, with the proposed addition, it will still function as one dwelling itself.
Yeah, I think what Ms. Murray is saying, that if this was a fresh start, and this was the lot conveyed, both lots together, the size of the house that is being proposed right now, does it fit within the bylaws on that property?
Well, through you, Madam Chair, if I can
Did I
go back
get
to
it
my
right?
previous point, if the addition was smack dab right on top of the existing dwelling, forming more massing without spatial separation between the dwellings, that's not something that staff would support.
No, you're not understanding the question. Yeah, okay. Okay, you go ahead. You,
No, about half.
Yeah.
I guess what I'm trying to get at is we're trying to get a much bigger house in a neighborhood, and if it was in smack dab in the middle, it wouldn't be permitted. So this is a way around the bylaws. That's what I'm asking.
Well, again, through you, Madam Chair, as Mr. Martino said, staff did agree that the design of the building, as the addition shows, allows that spatial separation to be obtained with the bridge connection there, and still gives the appearance of two distinct dwelling units, which is in keeping with the character of the area. And that's what we tried to maintain when we initially met, to have the dwelling, or the addition shifted over to provide that space.
okay.
Thank you.
Any other questions or items of clarification? Mr. Martino, do you have anything further to add?
Not at this time, other than we've read the staff's report in support of the variances we're seeking tonight, and concur that it meets the four tests of the Planning Act and is minor in nature.
Okay, so we'll take this matter into committee. Who would like to start the ball rolling? Go ahead, Mr. Talansky.
Thank you, Madam Chair. This is clearly a unique application, a unique approach. I think with all the line of questioning, it comes down to, does what appears to be two 5,000 square foot buildings fit the character of the neighborhood more than what would be a 10,000 square foot building if it was designed as one house that looked like one dwelling? I think the answer to that is yes, Madam Chair. So I'm going to move that this application be approved, finding that it does meet the four tests of the Planning Act. I would note that there were 2 letters of support from the community, and I would make that approval conditional on 4 conditions. First, that the addition be constructed in general accordance with the drawings dated January 29th, 2020, that the accessory building not be used for a self-contained second dwelling unit, and the approval expires within 2 years if a building permit is not issued, and that 62 and 70 Ennis Clare merge on title.
That's the last one, yeah. Is there a discussion on these recommendations? I see none. All those in support? Okay. All those opposed? Okay. Very well, your application has been approved.
Thank you.
Oh, yes, we need to move the 70 and Ennis Clare. Because they're together, okay.
There is a 2 decisions.
Yes. So, Mr. Talansky, do you want to lead that one since you already took on 62? We have to move the conditions to match for 70 Ennis Clare.
Certainly, Madam Chair. Madam Chair, for similar reasons, I'll move this application also be approved, finding that it meets the 4 tests of the Planning Act, and I'd make that subject to the same 4 conditions.
Okay, very well. Any discussion on this recommendation? See none. All those in support? Okay. All those opposed? Okay. Application has been approved.
Thank you very much.
Thank you. All right. The next item on our agenda is CV 029 of 2020 at 556 Weir Avenue.
Good evening. My name is Joris Kieran, Kieran Design. I'm the agent for the applicant.
Good evening, Mr. Kieran. Who is here for application CV 029 of 2020 at 556 Weir Avenue? Okay, show of hands. You're in opposition or in support, sir? You're in opposition. Okay. Mr. Kieran, would you kindly take us through your application, and then we'll give the gentleman in the back a chance to address the committee.
Certainly, Madam Chair, be happy to. This is a proposal for a 2-story dwelling, 4 bedrooms. The application is pretty straightforward. It's a 4-bedroom home with 2-car garage, and pretty typical of what we do on these size lots. Great room, dining room, study, things like that. 4 bedrooms on the 2nd floor, slightly enlarged bedroom number 2. Call that a second master. That's part of the justification, or part of the reason why we're requesting the additional square footage. That's the front elevation. It's a stone and stucco dwelling, meets the height restriction limit, and it meets all the other bylaws other than the 2 variances that we're seeking this evening. The 2 variances that we are seeking are number 1 for the front yard setback. There's a slight decrease in the front yard setback from what's permitted. And that was a suggestion actually from staff, which we agreed to and thought was a good idea, and it's really just to bring the house in line with the neighboring dwelling. So we thought that was a good idea, and we added that as a variance, and that's being supported by staff, as well as the other variance, which is for the increase in gross floor area. Just back to the front yard setback variance for one quick moment. The house would also fit on the property if we were to move it back. So we don't need that variance. It was just a suggestion, and it's one that we think is a good idea. As far as the square footage or the RFA variance that we're requesting, just wanted to speak to that a little bit. What's allowed on the property now is approximately 3,100 square feet, and what we're asking for is 32. No, sorry. It's 3314. Okay, and that is an increase of 6.9% over what's allowed. And as the committee is probably aware, my firm also did the house next door and the one next door to that a few years ago. And just to put that into context, so the house immediately next door at 552, we were approved for 3324. That is an increase of 7.2% over what's allowed. And then about 4 or 5 years prior to that, the house next door to that at 456 Weir, we were approved for 3,400, and that is an increase of 9.7% over what's allowed. And the reason I'm just mentioning these numbers is because I just want to point out that the variance we're seeking tonight is actually the lowest of those three. So our request is pretty moderate, considering those other houses. Lastly, we are building a new, well, my client is building, we designed a house at 583 Weir, which is a slightly larger property, but it's on the street, on the same street nevertheless, and that house is 4,600 square feet. It did not require a variance because that property is bigger, but again, just to provide some overall context to what's happening on the street. And how it relates to what we're asking for tonight. We did canvass the neighborhood, and my staff and I reached out to all of the immediate surrounding properties. The houses on either side and the houses directly across had basically no objection to it. We didn't get a letter of support from them, but they had no objection per se to what we were proposing. The house immediately to the south at 552 did provide a letter of support yesterday, so I just wanted to provide that to the committee tonight. And I have copies. Sorry? Oh, you did get it, okay. You want copies anyway, right? Okay, here they are. The other thing I wanted to mention is that the neighbor directly behind the subject property, which is on Wellington Crescent, Mr. Adam Clark, I did speak with him. I believe he's here tonight, and he has some concerns about the trees on the property. I think that's his primary concern, and we were able to discuss that and come to some understanding. I'm not going to speak for him, but I'll just mention what we have agreed to so far. So he is directly behind the subject property, and he's concerned with the trees in general in sort of two specific ways. One, how it affects his privacy to his backyard, and also just on the streetscape on Weir, which is just pertaining to the trees that are in the front. So what we have proposed and what I've added to the drawing, and I'm prepared to submit that into the committee tonight as well if need be, is the addition of 3 new trees being planted here along the back property line to fill in the privacy screen, if you will, to provide additional privacy for Mr. Clark. So that is on the drawing, and we can submit that into the process if required. His concern also pertained to some of the trees on the front of the property. There are 3 trees on the front. These 2 trees, which are closer to the proposed dwelling, as I mentioned to him, I don't think there's any way to save those because the front walkway's there. The overdig of the proposed house would kill the roots anyway. So those 2 trees are pretty much gone. This is a discretionary removal, which is a larger tree, and I think that is probably his biggest concern, I would say. And I was upfront with him, that tree is not required to be removed for the construction, but that's at the owner's discretion. They basically want to remove it. I also mentioned to Mr. Clark that the removal of that tree is not really at, part of this approval tonight. We do not have approval to remove that tree yet, and we won't until we go through the tree permit process, and it might still be rejected at that stage. So it's noted to be removed in this drawing, but that's just a suggestion and sort of the desire of the owner at this stage. But I mentioned to him that he can pursue this further with the forestry department to see if he can persuade them otherwise, and he's free to do that. So I just wanted to remind him and the committee that tree is not really, we're not seeking to remove that tree as part of this approval tonight. Yeah, that's about all I have to say, so I can answer any questions if there are any.
Any questions or items of clarification, Mr. Kieran, at this time? Okay, Mr. Hassan, we have a question from Ms. Murray for you.
Through you, Madam Chair, to town staff, question about the planting of the trees in the rear. It's my understanding that while it can be added, it is not enforceable. Just
Through Madam Chair, that's correct. The property is zoned RL3-0, so that's within the Suffolk zone and would be subject to the development engineering site plan review process.
thank you.
Any further items of clarification? Okay, I see none. So Mr. Kieran will just give the neighbor a chance to address the committee. Good evening, sir.
Good evening, Madam Chair and committee. My name is Adam Clark. I reside at 557 Wellington Crescent. We've been there for about 5.5 years now. We've seen the change in the neighborhood. So the goals of the meeting tonight are just to maintain sort of that character of the neighborhood of what my wife leaving Toronto and I to come to Oakville because of the character and find an older spot to live. And sort of as we've moved here, we've seen huge change just in our neighborhood. And you can understand the amount of properties Korean Design has already taken part on within our community as well. So I just wanted to show sort of a picture of 2017. I was here a year ago for 552 Wellington to protection of the trees, the protection of the privacy. And I'd like to draw your attention to about right here of our backyard. And this is now the current property in the back. So the privacy's gone. The trees that were there were totally removed as well. I have been in contact with the city as well, with Darnell Lambert and Michelle Dremenak. I hope I'm pronouncing that right. I had an email sent out on Wednesday with Darnell. Michelle Dremenak was on that, and she's supposed to be getting back to me, hopefully soon, because I just want to bring her to the attention of the trees on the property to save them. I do appreciate the time that Mr. Crean has given on the phone as well to work together, because I know the variance is probably going to go through for the most part, but my hope is to work together to provide the maturity of the neighborhood, to keep the character of the neighborhood, and to provide my family and I privacy in the backyard as well. So I'm just going to show a couple more pictures of what the house is sort of looking like. That's from our bedroom view. So that house is going to have a direct view into our bedroom now. This one here is a view from our kitchen that's changing. And if you look, this is the proposed property that's going to be changing right here. So it's going to dramatically change the privacy in our backyard as well. With that, I know within the back, as Mr. Crean has stated, within the drawing, I have here somewhere. that there are trees that are going to be coming down within the back, and there's only the one tree that is proposed to come down in the backyard. And that is this tree right here, to make way for a porch. So I do appreciate them hoping to plant some more trees along here to give us the privacy that we are starting to lose as well within our neighborhood, being there for 5.5 years. The proposed trees to cut down the front are concerning. This is the front of the house. There's 3 trees there. That first one in the front has a diameter of 70 centimeters, which is about a 3-meter circumference around. And that, to me, that's a huge tree. From my understanding, the replacement of that tree would only be 150 centimeters, which to me is sort of injustice. So that's why I'm working with hopefully with the Forestry Department to bring awareness to these bylaws as well, because from my understanding as well, that a tree on 15 centimeters or less does not need permits to come down. So those are free to go down. So the whole objective is to keep that maturity of the neighborhood, that character of the neighborhood, which we did talk about earlier. And these land variances have sort of been set standards where it's just, they just get bigger and bigger. People ask for more and more. And do we really need that when there's lots of bungalows within the neighborhood as well, that people have wonderful, wonderful homes with that as well. And the concern with some of these is real estate agents are buying these houses, making decisions, and then other people are moving in without knowing what was done on that property as well. So every time that a variance is being granted, trees are being lost, privacy is being lost, and the character and the feel of the neighborhood is being lost as well. My goal is more suitable bylaws as well. And then why are we always increasing the variance when we're asking for those going through? And then what are the replacement trees going to look like? They won't even be higher than my fence. So I won't be enjoying those trees for probably 10 to 15 years. This is a tree that we had planted for when my daughter was born. So this tree right here is at 8 centimeters diameter for the tree. So it wouldn't need a permit to cut down. And it stands, unfortunately, there's no leaves on it. This tree stands 20 feet in front of our house. So this is an example of a tree that would not need a permit. It's basically half the size that would be needed for a permit to take down. So very concerning as a member of the community, just hoping that my voice is heard when these variances are going through, and we can take more consideration in the trees as well. As I said before, I do appreciate Mr. Crean taking the time to discuss with me, hopefully work together to ensure that character is maintained, that I know that is a discretionary tree at the front, and hopefully if it does need to come down, I can go through with an appeal process to ensure that it is, because when bigger homes are going in as well, it is disrupting the green space within the neighborhood. Our neighborhood is just brought up from a basement mitigation project because the basement's flooding in the neighborhood, because green space is disappearing within the neighborhood with the new big homes, also with what's going on north Oakville as well.
Okay. We thank you for your submission. Can you put the first picture up where you showed all the trees a year ago?
That was 2017.
So I recognize that the one standing a little bit bare, that's an actual tree, and that's in the other picture as well.
This one, yeah,
that one.
I can-
The other
yeah.
ones, are they trees or are they just shrubs?
There was trees lining right back here.
Okay.
As you can see, you can sort of see them here. That sits down from where we are because there's a bit of have a little bit of an elevation as there as well.
Okay.
But you can see how much privacy we've lost just
Yeah.
with.
Unfortunately, people have a right to build two-story homes, and a lot of these areas are being developed from bungalows into two-story homes, and you can't stop that from happening. As Mr. Kieran said, we don't have a way of enforcing in terms of trees removal. That goes through another process that you're well aware of now. What I can say for the site development, the development engineering site plan process, that'll cover drainage and grading and all sorts of those elements that you can go back and if you're having issues with flooding, as you mentioned, that would be the process to make sure that your concerns are met. Are there any questions, Mr. Clark, at this time? You have a question for staff. Just stay there one moment.
Okay.
Go ahead.
Through you, Madam Chair, to town staff. My question is, often we see applications and we see an arborist report with those applications. Are we in a situation where the arborist report is, we see them because it's in advance of the site plan, or we see it because it's been asked for by the city?
I don't know, Mr. Hassan?
Yeah, through you, Madam Chair, it'd be situations, as you allude to in terms of the latter, they would be in relation to applications where we feel like it is necessary to preserve trees in certain situations based on comments from our landscape architects. And so those are asked for through the submission of the minor variance application. So that can be assessed prior to the development engineering site plan approval application being applied for.
Okay, so just to follow up, Madam Chair.
Yes.
So it's possible that we just haven't seen comments on that just yet?
Through you, Madam Chair, I'd have to confirm with Mr. Kieran, but I don't believe a development engineering site plan approval application has been applied for to date.
Understood, thank you.
Okay. Did I cover all the points that you
I
mentioned?
would just ask, since that tree doesn't need to come down within the drawing that we have there of the, of 556 Wellington, is it possible to have a new drawing where that tree isn't labeled to come down?
No,
I'm not
this
too
is,
sure.
we have to take in the applicant's drawings as they are, as they submitted with the application. But as Mr. Hassan clarified, through the development engineering site plan, they will make a decision whether that tree continues to be marked down for removal or not. We just have to deal with the variances that are before us. And the two that are before us right now is the maximum residential floor area and the front yard setback, which was not really their choice. The town staff recommended it and they obliged, and as he explained. Is there anything else?
Yeah, I guess my last question for the committee would be, would trees be considered a part of the character of the neighborhood?
Mr. Flemington, you have a comment.
Sorry.
I saw you waving. Go ahead.
Sorry, Madam Chair, before you get to that question, I just thought, based on your last comments, the gentleman should be aware that he has an opportunity to go and talk to that committee
Yes.
with regards to the vegetation and everything, so that they can hear that. It's not here that,
Yeah.
Yeah.
Thank you
And
for
I'm waiting-
clarifying. I thought
yeah.
I made that clear, but thank you. I appreciate you
Thank you.
clarifying that. It is a different process, and you get to voice your opinion
Yeah.
and get all your questions answered. I'd like to field questions pertaining to this application, those two variances.
Okay.
Do you have any more, or
Nope.
no?
No, it's just,
Yeah,
just
I understand your
unfortunate, right?
frustration. It's
Yeah.
just that our hands are tied. We can't deal with arborists' issues. We can't deal with
Yeah,
the trees.
and I'm just hoping to hear back from the city from Ms.
I'm sure if you
Jemanek.
leave your name and number with Mr. Hassan, I'm sure he can make sure that whoever you spoke to will continue to liaison with you and get you the information. They do try to stay on top of answering all the questions from the public. You are right in terms of working together as a process, both the town staff as well as the neighbors. So I don't think your comments are ever going to go on deaf ear just to give you peace of mind.
Okay, I hope
But I
And that
do
would be the hope.
understand your frustration.
Yeah.
We see it all the time, and it's frustrating for us too, because we can't comment on these things.
Yeah, absolutely.
Yeah.
I totally understand. Thank you for your time tonight.
Okay. Mr. Kieran. So if you have anything further to add or any items of clarification that you want to make before we take the matter into committee, this is your time to do so, sir.
Sure. Just sort of to reiterate then and confirm that, yes, we do intend to get an Arbor Support for this property as we do normally. Our standard practice is to do so after the variances are approved. That's when we move into that phase of the approval cycle, and we get all those documents prepared. And then we will go through the tree permit application process, and then that tree will be dealt with separately, and we don't know if we're going to get approved for it or not. What I do know is the formula at the moment for replacement trees on a tree of 70 centimeters in diameter, the replacement requirement would be about six new trees. So that's part of the reason I offered up to 3, because we can plant at least 3 of them along here. So if the tree is removed, then we'll be required to replant 6.
Thank you for those points of clarification. And you did very well speaking to Mr. Clark before the meeting, so I urge you to continue your communication
Yep.
with him so that he's aware of the process and his voice continues to be heard.
Yep,
Thank you,
no
I
problem.
appreciate that. Are there any items or questions items of clarification or questions of Mr. Kieran before we take this matter into committee? Okay, I see none. If you're satisfied with the conditions that town staff have suggested, then we will take the matter into
Okay.
committee. Very well. Who would like to move a motion? Go ahead, Mr. Flemington, thank you.
Thank you, Madam Chair. I would like to move a motion in support of the application as applied for, recognizing that I have conducted my site visit, noting that the town's staff report is in support of the application. Also noting that there was a letter in support of and another letter in opposition of, and also noting that the comments from the neighbor this evening commenting his objections with regards to the application. I think we spoke to, the avenues of which he can pursue that, because it's not upon us we're not able to police with regards to the trees, and also hearing from the applicant's agent that they are willing to address some of those concerns. So having said that, I'd like to move the motion, finding that it meets the 4 tests of the Planning Act. And I would like to include the following 2 conditions: that the dwelling be built in general accordance with the submitted site plan and elevations dated January 31st, 2020. And our standard condition that the approval expires 2 years from the date of the decision if a building permit has not been issued for the proposed construction.
Thank you, Mr. Flemington. Is there a discussion on this recommendation? I see none. All those in support? Okay, the application has been approved. Thank you. Okay, the next item on our agenda is application CAV 030 of 2020 at 1056 Truman Avenue. Good evening.
Good evening, Madam Chair, members of the committee, staff. My name is Amin Bassi. I'm the applicant for CAV 030 2020.
Okay, good evening, Mr. Bassi. Who is here for application CAV 030 of 2020 at 1056 Truman Avenue? Okay, I see none. I know this application is for a maximum height variance. Go ahead, sir, this is your time.
Sure. So the home was originally designed within zoning. However, 2 issues have resulted in this application for an additional 31 centimeters to the overall height. One, the foundation was incorrectly poured 10 centimeters too high. And secondly, the truss package was built 29 centimeters too high. In result, it moved the building from 8.92 meters up to 9.31 meters. As city staff has noted, we are still maintained and protected the character of the neighborhood with the new 2-story dwellings in the immediate area. Also, the facade of the dwelling is broken up into varying sections with multiple roof lines, which visually reduces the scale of the overall building. I'd be happy to answer any questions from the committee.
And we do have 2 letters of support from your neighbors.
Yes, adjacent neighbors on either side.
Yes. Are there any items of clarification or questions? Go ahead, Ms. Murray.
Yes. The house is already built, and I understand what has happened. How do those things happen?
So with the foundation, it appears that the approved survey included a smaller picture on the lower left-hand corner, which had incorrect finished floor height. That was actually, went through the process and was part of the building permit that was approved.
Okay.
And unfortunately, it appears, and I am making an assumption here because I haven't been able to get a clear response, unfortunately, from the contractor, but it appears that he has poured the concrete to that height.
Okay. And the response with regards, how does that happen with the truss?
I don't have a response yet. The framer did install the truss and felt that there was no issues that he saw while installing them. He had no concerns. It appeared to all be according to the plan. It all lined up and fit together. Unfortunately, though, once we realized that we had this issue when we did our as-built survey or as-built measurements, he went back and measured it and realized that there was it was poured or it was built too large.
So I think I don't know if it said on here who was the contractor.
The contract for the concrete was Brain Concrete, based out of Hamilton. And for the truss package, it was Turkstra Lumber.
Thank you.
Any other items of clarification or questions of Mr. Bossy at this time? Okay, if you're satisfied with the conditions the town staff have included in the report, we can take the matter into committee now.
Please.
Okay. Who would like to start on this application? Mr. Talansky, go ahead.
Thank you, Madam Chair. Madam Chair, this application brings back unfond memories of when I built my house. And my foundation was almost poured a foot too high because they put the benchmark in the wrong place. So I do understand how these things happen, but that's really not the test that we have to deal with here. But in my site visit, despite the variance, Madam Chair, I did not find this house to be the tallest looking house on the street, with a fair number of new builds on the street. So I see no impact arising from the variance. So Madam Chair, I'd be happy to move that this application be approved as applied for, finding it meets the four tests of the Planning Act. Would note that there's support, 2 letters of support from the community. And I've lost my page on the conditions, but I would move the application be built in general accordance with the drawings submitted, dated, thank you,
September 9th.
September 9th, 2019, and that building permit issues within 2 years.
The elevation drawings are dated August 2018, submitted with the application. That's part of the other condition.
Take that as a friendly amendment.
Thank you. All right. Is there a discussion on this recommendation? I see none. All those in support? Okay. Application has been approved. Thank you.
Thank you.
Okay, so we are dealing with application CAV 032 of 2020 at 1670 North Service Road East.
Good evening, members of the committee.
Good
My name is
evening.
Paul Demchek of Batory Management, and I am representing King Ridge Developments, the owner of the subject lands.
Good evening, Mr. Demchek. Who is here for application CAV 032 of 2020 at 1670 North Service Road East? Good evening. Are you here in opposition or in support? In opposition. You're in opposition. Okay, Mr. Demchek, please take us through your application, and then we'll allow the neighbor to address the committee.
So the proposed development is at 1670 North Service Road East. The subject lands are currently vacant, and what's being proposed is a 3-story commercial condominium building. I will note that together with the adjacent site at 1660 North Service Road, which is to the south, this was part of an original development being a 2-phase condominium. And that zoning and approval originally was approved prior to 2014. I believe it was originally constructed over 10 years ago, and it was approved under the previous bylaw. The subject site at 1670, for the benefit of the committee, was actually site plan approved for almost an identical configuration to what you see before you today. In 2015, there were not only site plan approvals, but also minor variances, identical again to what you're essentially seeing today, that were approved by this committee. However, both of those have lapsed. The property changed hands, and my client has purchased it and is looking to essentially reapply. We have a current site plan application in, and we are here before you today as well for the variances that I'll be speaking towards in a second. For the benefit of the committee, again, the access to the site is designed and permitted through the adjacent property at 1660 North Service Road East. There are existing easements over both properties, which legally allow for this vehicular access, servicing to the lands, etc. And that's seen in this site plan in front of you on the screen. So the proposed variances, there are 4 variances we are seeking. These are the requirements and requested variances that are shown in the notice that was provided to yourself as well as adjacent neighbors. For the benefit of the committee, I'll walk through each one. So variances 1 and 2 are somewhat similar in nature and tied together, being the proposed drive aisle and landscape. So specific to the drive aisle, under the current 2014 zoning bylaw, drive aisles are permitted to be shared on property lines. However, the drive aisle must be essentially located right in the middle where the property line is. In this case, the existing site condition is that the drive aisle is located at the edge of the property line on 1660 North Service Road.
Sorry to interrupt. Can you illustrate on the diagram that's?
Sure. I think I can use this. Right. Sorry. Right here. So under the current bylaw, as I was mentioning, the drive aisle is essentially supposed to be located right in the middle of the property line. So here's the property line right here. As you can see, the middle of the drive aisle is located offset, roughly 3 meters from that property line. So that what happens is the existing condition, you have to have access to these individual spaces, not in accordance with essentially with the bylaw. So we are seeking a variance to the drive aisle for that existing condition. And then, which is tied together with this, is variance number 2, which is a 3-meter landscape buffer on this side of the property. Because of this existing condition and to essentially fulfill the intended development, we are proposing obviously not to have a 3-meter buffer along this property line, which is the southern property line, and ask for a 0-meter setback. So, and that allows for the site obviously to function in a continuous fashion, and that is obviously to make the site work from a built-out perspective. I will note for the variance to the landscape, although we are not having any buffer on that southerly property line, we are still meeting the canopy coverage and tree planting requirements by the town through our site plan process. Variance number 3 relates to a landscape buffer on the northerly property line. We essentially have a pinch point, which is located right here, sorry. So that pinch point, the landscape buffer is required to be 3 meters. We have roughly 1.3 meters of landscape, and then it, as you can see, it tapers out as you get towards the back or easterly portion of the property, and flares out that way. Again, this design is identical to what was previously approved by this committee back in 2015, as well as previously approved site plan by town planning. And finally, there is a variance for a proposed walkway. So walkways under the current zoning bylaw are allowed to cross. So essentially, if you could imagine, here's our front entrance to our building, and we have this access here, and planning staff asked, and urban design asked us to connect our walkway to the sidewalk along North Service Road. However, because of the existing grading difference, we had to do what you see here is a accessible ramp. So we have this walkway that does not cross, but is within the proposed buffer, landscape buffer, and that is not permitted by the bylaw, although requested by planning staff. So we worked with planning staff to come up with this solution to make our site work to connect to the sidewalk in an accessible manner. So there's both a staircase here that you can see, there's steps, but also we have an accessible ramp there. So for the benefit of the committee, I did provide a planning report that supported the variances. I've read the staff report that's been provided to you. I have no other comments for the committee. I'm happy to hear if there's any questions and answer them.
Thank you, Mr. Demchak. Are there any questions or items of clarification, Mr. Demchak, at this time? Mr. Flemington, go ahead, sir.
Through you, Madam Chair. For clarification, so you refer to the application that was back in 2013, and is it am I understanding correctly, at that time, the ownership was all one, so that this was a plan for that site, and then since then, the ownership has changed. So as a result of things being split, these variances are now required, or part of them are required because that the land has been split based on that ownership change? Is that, am I correct thinking that?
Right, so the ownership, I don't know the exact dates, but the ownership has changed a number of times over the past decade, we'll call it. So this development, existing development, on the right side of your screen, the existing two-story commercial building, that was built roughly just over a decade ago. I believe it was built by Legend Homes at the time. The subject property on the west, that was also owned by Legend Homes at the time, they sold it roughly a decade ago. Again, it's changed hands a couple of times. And during that course of time, there was some landowners that did achieve both site plan and zoning approvals for this configuration that you see before you today. We're essentially here before you to reactivate that.
Thank you.
Go ahead, Ms. Murray, I see you reaching.
When I did my site visits, I didn't see any signs up. Are we gonna put some signs up,
For
the notice?
So there is a notice sign. I sent the notice sign picture to Jasmina
Yep.
when it was required to be posted. It's actually on the billboard sign. There's a big marketing billboard. So it's on which is in the middle of the property, but it's on the bottom corner of that big marketing sign. So Jasmina had sent me a request today to confirm that it was up. So I sent a picture of that confirming that it was up today.
And Jasmina has a comment.
Yeah,
To
thank you.
Madam Chair, yes, I forward to
Yeah.
you the pictures that he sent to
Yeah.
me, and I believe it was there maybe like on the sign, that's why like
Okay.
appears you didn't see it.
Any other items of clarification or questions before we ask the neighbor to address the committee? Okay, I see none. Okay, thank you.
Thank you.
Good evening.
Good evening, Madam Chair, members of the committee. My name is Samantha Richmond, and I am an owner of two of the units on the north side of the neighboring building. And I have
Your
concerns
address
about,
for the record?
my home address or business address? Home address, 2442 Mill Run Drive, Oakville. We're concerned about the proposed variances numbers 1 and 2 as it relates to the shared access and no landscaping between the two properties. In speaking with other owners and members of the condo board who were not notified of this meeting, I'm advised that they were under the impression that the new building would have its own driveway and not be relying on solely on ours to access the property, and that there would be a divider between the south lot line of their property and the north lot line of our property. The issue of the driveway is not before you, but we do have concerns with variances 1 and 2 that are being sought. To my knowledge, our building has fewer units and more parking spots than what is proposed in the new building. So I see that there's already, it's already tight in terms of parking for the proposed building. With no divider between the two parking areas adjacent to the buildings, I think it's going to cause a lot of further problems for our parking situation, because people will think that the spaces are available for anyone, regardless of which building, and we will have people from the new building parking in our parking spots on our side of the parking lot. In addition, there will also be issues regarding maintenance and wear and tear and that type of thing over our parking area. As I understand it, the shared access is supposed to be between the two properties, whereas this is completely on our property. And that is all I have to say.
Okay, we'll have Mr. Demchek respond to your concerns and
Certainly.
get you answers to these questions. Is there anything else? Because once you sit down, he answers and then we take the matter into committee. So if you've mentioned everything that you have, then we can proceed.
Well, I believe that there's supposed to be the landscaping. That is what the bylaw is for, to have a proper division between the properties. And the fact that there's not enough room on the lot, given the size of the building that's been designed to accommodate enough parking spots without encroaching on our access way, it shouldn't be that burden shouldn't be put on us and compromising our parking and use of our building.
Understood.
you.
We've heard that. Thank you. Mr. Demchek.
Thank you. So I heard concerns about the shared access. A few comments and that I'll run through. So in terms of only providing the existing access and our site being accessed through the existing access point on 1660 North Service Road. This site was developed comprehensively, like I mentioned, over a decade ago, and one of the issues at the time, and I can imagine would still be an issue, is that the MTO, because of its proximity to the Ford and QEW intersection, they did not allow or would not allow a second drive aisle further than what it is today, and that's why, as you see, it's essentially where the access is on the site. It's the furthest away from the Ford and QEW intersection, which is, when you're looking at the screen, further up towards the toward the left of the site. That's the first comment I have. Regarding the shared access and the buffer strip specifically. So buffer, in the situation where you have as I mentioned, the condition of a shared access right on the middle of the property line, a buffer strip is actually not required under the current zoning bylaw. However, because of our configuration and where the shared access is specifically located, the zoning department specifically said we should be seeking a variance for that to recognize this condition. So that is why that specific variance is before you today. I heard some concerns regarding parking. I will note that the parking on just 1670 North Service Road, which is what we are proposing, not only meets the parking standards of the town, but also has an excess of parking roughly by 9 spaces, further than what the zoning bylaw requires. And I will note the intended development, like what you see before you today in its configuration, building, siting, design, access, it was approved comprehensively over a decade ago. There was a site plan application that was approved roughly 2015 for this development, and again, it lapsed. We are before here today to reactivate that.
And then in terms of the buffer, you still have landscaping. It's just that the variance was triggered because of the location.
Of location of the shared drive aisle. Okay. So buffer strips along where there is a shared drive aisle that meets the definition of the zoning are not required. But because we don't meet that definition, zoning says we need to have a 3-meter buffer.
Okay.
Yeah.
You have an item of questions, and Mr. Hardcastle, yes, I see you. Go ahead, Mr. Flemington.
Through you, Madam Chair. Sorry, you keep referring to the plan that was provided before. Was that for a 3-story building?
So at the time, I believe it was for a 2-story building. Yeah.
Okay, thank you.
Yeah.
Mr. Hardcastle, go ahead, sir.
Thank you, Madam Chair, and through you, you had indicated that at the time of development of the first phase, the
Yes.
existing development, that there were easements put in place. Is that what I heard you say?
Yeah.
So there are easements put in place over 1660 in in favor of 1670 and vice versa?
Yes, so those easements are not only noted on title, but they are also noted within the condominium documents of 1660 North Service Road. For the benefit of the committee, my client, his office is in 1660 North Service Road. So he has a condominium unit within that building as well. So that those documents were provided to the town as part of our site plan application as well.
And sorry, but just confirming there, it's on both properties reciprocal?
That's correct. They
for
are
one
reciprocal
another.
easements,
Okay.
yes.
Thank you.
Ms. Murray, go ahead.
Through you, Madam Chair, to the town staff. My question is about if they are sharing that driveway via property line, where does liability come in? If there is an issue, an accident, a slip and fall, I mean, is that covered under the easement? I don't.
Yeah, through you, Madam Chair, I don't believe the town would be involved in anything related in that situation. It'd be a civil matter. In relation to the mutual drive, if I can sort of explain further, if the existing property line was shifted just slightly to the right where the dotted property line was, as Mr. Jemdek has said, the landscaping requirement would not be required. But further to your point, again, the liability would fall on the property owners themselves.
Okay. Mr. Hardcastle, go ahead.
Thank you again. Are you aware of, or is there a contemplation of some form of a maintenance agreement with the existing condominium corporation? And are there provisions provided within that condominium corporation or ability to amend those documents to deal with maintenance responsibilities, to share snow plowing, asphalt repair, whatever it would happen to be associated with both sites utilizing the access at 1660?
Yes, so those arrangements within the existing condominium documents do exist, not only for snow clearing, but as you mentioned, for maintenance and repair of drive aisles, as well as for garbage. There is shared garbage facility for both condominium developments.
So there's arrangements to ensure that there's financial compensation to ensure fair and equitable use of those things in maintenance, right?
As far as I'm aware, based on what the legal team has told my client and myself, yes.
Okay, thank you.
Mr. Flemington, did you have something further?
I was just curious, like, based on that, from the common areas, is it the same condo corp that would be dealing with the condo area?
No, it's two separate condominium corporations.
Thank you.
Yes.
So as a follow-up to Mr. Hardcastle's question, did they enter into a legal agreement if they're two different corporations, condominium?
So there's existing reciprocal easements
Okay.
across both properties, yes.
Okay.
And Madam Chair, the second condominium corporation doesn't exist yet, so it would be my understanding, and maybe this is a question of staff, upon creation of the second condominium corporation, they would be required to, or the developer on behalf of the yet-to-be-registered condominium corporation would have to enter into those negotiations and discussions to finalize any agreements that have their genesis out of the existing condominium docs in 1660, or for 1660.
Yeah, through you, Madam Chair, that's my understanding through discussions or discussion with the staff reviewing the site plan application.
Okay. Thank you for those clarifications. Any other items of clarifications or questions? Ms. Murray, go ahead.
Through you, Madam Chair, to town staff, are there any unintended consequences of having this shared driveway that we have seen historically?
Through you, Madam Chair, unfortunately none that I can recall or bring to the committee's attention.
Okay, thank you.
Okay.
Through you, Madam Chair, to the applicant, is this entire building 100% office space?
Yes.
And then to the staff, from a density perspective, so where I'm going is based on the neighbor's comment with regards to the
Parking spaces?
Pardon?
Parking spaces, right?
Yeah.
Yeah.
Based on their comments about, they have a building that has a significant more number of parking spaces for their gross floor area versus this. That's where I'm getting to the density perspective. Like, I find that, just in my opinion, like for the gross floor area of this building, you know, having only 3 spots per 1,000 square feet is quite low from a density perspective. So I've read the staff report and recognizing that the staff supports the different variances, but from a density perspective, you know, and also considering that the comment that I asked that previously the overall development of the site was originally looking at possibly 2 buildings at 2 stories each. Was there any consideration given based on the density of the gross floor area of this building as it relates to the parking?
Yeah, through Madam Chair, through discussion with the planning staff that were reviewing the site plan application, the density wasn't discussed, noting that the total GFA for the building results in the parking requirements, and then furthermore, that they're oversupplying the parking that's required in the zoning bylaw.
Go ahead, Ms. Murray.
Thank you. Through you, Madam Chair, to town staff. We've seen applications before for commercial development of this nature, and it often comes with a parking survey. This does not have one. What's the difference between that and other applications we've seen?
Through you, Madam Chair, I believe that was submitted with the site plan application, but wasn't warranted for the minor variance, just because there was no variance required for this proposal.
Okay, thank you.
Yeah, I guess when they meet the requirements, they don't have to. Yeah. Any other questions? Okay, are we ready to take that matter into committee? Mr. Demchak, you're familiar with the recommendations of the conditions for town staff, and you're satisfied with those conditions? Okay. All right. Gentlemen and milady. Mr. Hardcastle.
Thank you, Madam Chair. Having reviewed the submitted materials, the written staff report, having undertaken a site visit, and heard the deputations from both the agent on behalf of the owner and a neighboring property owner, and the conversation and numerous comments from the committee, I'm prepared to put forward a motion of approval. I believe that this site was contemplated from origin to be developed in a comprehensive fashion. I believe that the constraints of the site, including its proximity to the MTO, restrictions associated with the QEW and the intersection of the service road, is driving a lot of the configuration requirements, and that there are adequate requirements in place to deal with some of the concerns that were expressed from the neighboring property owner with respect to access, maintenance, parking utilization. And I believe that the variances that are being requested are driven by the comprehensive development configuration and slight adjustments to the location of the parking relative to, or at least for 1 and 2, relative to the common drive aisle. So as I said, I believe that these variances conform to the 4 tests of the Act. And I'll put forward a motion of approval subject to 2 conditions. The first being that the commercial building be built in general accordance with the final approved site plan to the satisfaction of the Director of Planning Services. And the second, our standard comment, condition, I should say, that the approval expires within 2 years of the date of the decision if a permit has not been issued.
Very well, thank you, Mr. Hardcastle. Is there a discussion on this recommendation? Mr. Talansky and Mr. Flemington, go ahead.
Thank you, Madam Chair. Madam Chair, I think my colleague put it very well, and I won't repeat his comments. I'd just like to add to it that I believe what we're dealing with here are purely issues that result from phasing. Had this been built at one time as it was planned, we wouldn't be having this discussion. Obviously, we wouldn't be here, but this is what happens when you phase projects. I deal with them regularly, and I don't think the issues are resulting from the variances being requested. It's just the fact that there's been a long time between phases.
Thank you, Mr. Talansky. Mr. Flemington.
Madam Chair, I just want to say that I am in support of the motion. I did ask my questions that did give me the answers with regards to the site from its original development and with regards to addressing some of the concerns that were raised by the neighbor with regards to parking. It is within the realm and it does support what the parking bylaws are. So I am going to support the motion as illustrated by my two colleagues.
Very well. Thank you. If there's no further discussion, all those in support of the approval? Okay, application has been approved. Thank you.
Thank you.
Do we have to, there's another, oh, this one is South Sheridan. Okay. I don't know, I was seeing double. Yeah. Okay, application CAV 034-2020 at 2930 South Sheridan Way. Good evening.
Good evening, Madam Chair, members of the committee. I'm here on behalf of the owner of both 2929 Sherwood Heights Drive, as well as 2930 South Sheridan Way. Madam Chair, and I'm here for both applications A03322020 and A03422020.
Very well, we understand. Both of them are for a lot area. One of them is being retained and one of them is being severed.
That's
Yes.
correct, Madam Chair.
Yes. It's just that I was seeing Sherwood Heights and we just dealt with another Sherwood Heights, so I thought there was an error in front of me.
Okay, thank you, Madam Chair.
Okay. Go ahead, this is your time. Feel free to take us through your application. Let me just canvass the room to see if there's anyone here who has interest in your applications. So who is here for application CAV 034 of 2020 at 2930 South Sheridan Way? Or, and 033, I have to read it from here because it's not on here.
It is.
No, no, it's not. No, it's not. Okay. Oh, okay. 033, I crossed Sherwood Heights. Okay. Then which one were we dealing with before? North Service Road. I apologize. Who is here for those applications? Are you here in support or in opposition, ma'am?
I'm just here for information.
Very well. Do you, would you like to address the committee? Or you're just going to listen?
I'm going to listen.
Okay, very well. Thank you. I'm sorry, I lost my train of thought. Go ahead, ma'am. It's your time.
Thank you, Madam Chair. Madam Chair, my client acquired both properties in 2016. Prior to that, each property, that's 2929 Sherwood Heights Drive and 2930 South Sheridan Way, each property was a legally created parcel. But because my client acquired both of them in 2016, what happened is they merged. And so my client wishes to convey 2929 Sherwood Heights Drive and is in the process of having a discussion with the town and has filed an application for an exemption from part lot control. But prior to getting that process by the town, a variance is required for each application in relation to the minimum lot area. Both lots together are approximately 1.41 hectares, which is less than the 6.0 hectare minimum lot area, which was introduced in 2014. So although my clients, each property was legally created, the minimum lot area at that time was 0.20 hectares. And that changed in 2014. So what my client requires in order to pursue the part lot control exemption application is a variance for each lot to permit the minimum lot area that is 0.90 for one of the lots and .51 for the other one. And both lots had that minimum lot area when they were separate lots, but unfortunately, because they merged, we have to go through this process again.
I see. Okay, very well. Are there any questions? Am I pronouncing your name correctly, Mahadevan?
That's correct, Madam Chair.
Of Ms. Mahadevan at this time? Or items of clarification? Okay. Judy, oh, sorry, I didn't see you.
Sorry, again, through you, Madam Chair, to the applicant, I didn't see any signs up. I made my site visit yesterday, and I didn't see any orange signs. So just a comment, so.
Through you, Madam Chair, and I apologize for that. We did ask our client to clarify, and they did send us photographs, so.
Yeah, you just place them in front of you and we'll be able to see them on our screens. Yeah, there we go.
And so this was taken this morning, and I do apologize if there was a situation, but they did send us photographs when we first were provided the signs, and then they resent photographs today as well, taken this morning.
Okay. It's just that these signs, they help us get to where we need to be.
I understand that. Thank you.
Yes,
And for everyone
it's for
else
the-
who's in the notification,
It's
yeah.
part of the process. It's
Yeah.
for the public, so
As
that
well.
then they have due process and they're notified as well. So
Yeah.
those signs should be up. All,
So that the neighbors are aware of what's happening and they can voice their concerns, or like that ma'am right there, come in and hear what is going on and get the information that they need. That's why they're important, not only for us.
Thank you, Madam
It's just a
Chair.
joke on my part, I apologize. Do you have anything further to add, or can we take the matter into committee?
Madam Chair, unless you have any further questions, it is my opinion and view that these variances are technical in nature in consideration of the history of the property, and they meet the intent and purpose of the official plan and the zoning bylaw, and are minor in this context.
Very well.
Thank you.
Ma'am, I'm going to give you an opportunity to ask any questions if you'd like, but you'd have to come and state your name and address for the record to make sure that we've answered all your questions. If not, then we're happy to take the matter into committee.
That's fine.
Perfect, thank you. All right, who would like, you have a question?
quick procedural question, Madam Chair. So we're deal with these separately or in one motion?
We're gonna move
Okay.
them separately, but yeah,
Thank you.
as we did the last
it.
time, yeah. Okay, who's ready? Mr. Hardcastle, thank you.
Thank you, Madam Chair. Having reviewed the written materials, undertaken my site visit, heard the concise but precise comments of the agent, I am satisfied that the requested variance conforms to the tests of the Act. Noting of relevance to me is the creation of the larger lot area requirement in 2014 and the owner's unfortunate merging of title through purchase, resulting in the need the need for the variance. The previously, under the previous zoning regime, these lots did conform to the lot area requirements. And the configuration that exists within that area is consistent with the lot area size and configuration that is present with this. And as such, I would put forward a motion of approval, subject to the approval expiring within 2 years of the date of the decision, if the proposed lot has not been created and received final approval. And that is with respect to CAV A033 of 2020, and I'll put forward the motion for this. I would note the, yes, thank you, colleagues, that there was a letter of objection received with respect to this matter, and I believe that the commentary that's been provided adequately addresses the comments provided within the correspondence.
Yes. Okay, is there a discussion on this recommendation? Okay, I see none. All those in support? Okay, application has been approved. So now, Mr. Hardcastle, would you kindly move the next application as well?
With respect to CAVA 034 of 2020, likewise, I have undertaken my site visit and reviewed the materials and satisfied with the materials before us, and I'll put forward a motion of approval subject to the same commentary provided with respect to the first application, and that the motion of approval should be subject to a similar condition, being that the approval expire 2 years from the date of the decision if the proposed lot has not been created and received final approval. Thank you.
Thank you, Mr. Hardcastle. Is there discussion on this recommendation? I see none. All those in support? Okay, the application has been approved. Thank you.
Thank you.
Okay, the last item on our agenda tonight is application CAV 019 of 2020, deferred from January the 28th of 2020 at 3358 Lakeshore Road West. Good evening.
Thank you, Madam Chair. My name is Russ Cheeseman. I'm the solicitor for the applicant here, Dr. Sharif Suriel, who is in attendance as well.
Very well, thank you, Mr. Cheeseman. Let me just canvass the room. I do see people leaving, but I don't see anyone here for this application. Regardless, I will. Who is here for application CAV 019 of 2020, deferred from January the 28th for 3358 Lakeshore Road West? Okay, I see none. Go ahead, Mr. Cheeseman.
Thank you, ma'am.
This is your time.
Thank you, ma'am. The variances, as you say, they were here back in January for 2 variances. Just before that, the application was to be heard by you. We got word from the zoning department who was reviewing the plans that there may have been some variances missed. So Mr. Cosell went over all the plans again, came back and indicated there were 2 additional variances. They are 3 and 4 that are set out there before you. And I'll speak to all of them tonight. I don't know if the committee is aware of the history of the site. The site has a long history. It goes back to 2012. When the original application for minor variance was made. Actually goes back a little before that, but that's when the application was made. And that resulted in the original variances being granted by committee on November 29th, 2016. This property was also part and parcel of the appeal of Oakville Bylaw 2014-014. It was involved in a site-specific referral of that, and that all got settled out by way of that minor variance application that was made back in 2012 and then finally dealt with in 2016. After that approval, there was a lengthy site plan approval process. Took some time to get site plan approval from the town. But in any event, building permits eventually got issued and construction began on the site. After the construction began, the client was dealing with his designer, Hicks Partners, who designed the building, and wanted 2 changes to be made, requested 2 changes to be made. One is to cover the front porch. The front porch under the existing design was just the stairs up to the front door. And so I'm going to place this document up here. Hopefully this will indicate and come through. There it is. That's the proposed dwelling. So initially, the front porch here wasn't covered. It was just open. So with the request to cover the front porch, basically keep the rain off you while you're opening the front door, that triggers 2 variances. It triggers one to the front yard because the front yard setback, stairs, unopened porches are permitted encroachments. But once you put a coverage on it, then it counts for setback. So in essence, that's the first variance that we're seeking. And then the second variance arising out of the front porch is the fact that when you cover it, Hicks has designed this, tied it into the roof line from here. That space triggers both coverage. There's a coverage figure because of the front porch is now a covered area, so that goes in the overall building coverage. And then the area up here gets tied into the roof, and that results in a small change to the GFA in the building. So, and I'll go through those for you. The front yard, let me deal with this one. The front yard first is the number that you see there, 5.06 meters, is based on the actual construction and excavation survey that has been done. That's the worst case scenario. That would be the farthest the porch could encroach. It may be a little less than that. And if it isn't permitted, isn't granted, then that's where the stairs, we'll just go over them. So it's, the approval back in 2016 was a 6.47 meter setback. Now, because the porch is going to be counted, it's a difference of 1.4 meters, which is about 4 feet, which is sort of the width of the front porch. So that's what we're seeking. And so in terms of that, that's simply why that is triggered. We see that as basically minor. And if you go look back at the January 28th report that was prepared by staff, they had no problem with that. That was, they didn't have any questions about that. The second variance with respect to residential floor area, and I spoke to that, we're talking about the amount of residential floor area in the building. That is a result of the roof on the porch. What was permitted was 33.3%, and what we're seeking now is 33.91%. So it's a difference of 0.61%, and it really is about 10 square meters in that roof area above, and it's about 115 square feet. It's in the roof line. You can see here that from the street, you're not going to recognize that. You're really not going to see that increase in GFA there. The new variances, the lot coverage variances I want to speak to, they arise out of the rear portion of the property. There is a pool pavilion that's been approved, that is part and parcel of the building permit application. And that building permit pool pavilion consists of glass panes. And the client was concerned because some of those glass panes come within about 2 feet of the swimming pool. So when you're walking around the edge of the swimming pool, you really haven't got a heck of a lot of room. So he wanted that to be moved back another couple of feet. So it's about that in certain areas. Mr. Cosell has calculated all of that area, and he has come back to say that that pool pavilion it has an extra, because of its size, is about 410 square feet extra. And so that, in addition to the coverage of the front porch, which is just the front porch area under the cover, brings us up from the 25%, which is permitted by the bylaw, to what's being sought as 27.92%. And I would just point out that the house, the GFA of the house, I'm just going to put this up, which is the plans and the table, as you can see. The GFA of the house is broken down here, and you'll see that the coverage, and Mr. Cosell asked us to break it down this way, you'll see that the dwelling was and always is 19.77%. And then if you went to the pool pavilion, which is classified as an accessory building, its maximum would be 5%. So 19.77 plus 5 brings you under the 25. So really what we're talking about now is the increase of 0.63% for the coverage of the front porch, which is 0.63%, and an extra 2%, say 2.32%, for the enlargement of the pool pavilion out away from the pool a little bit. That's what this application is all about. And just to put it back in your mind, the RL2-0 zone means that all of the gross floor area gets counted into that number. There's no accessory building exclusion, as there is in other zones. So that it's all part and parcel of the way that it gets calculated. So that is basically what we're here for. And in my respectful submission, those variances are in fact quite minor and meet all of the 4 tests of Section 45. Now, having said that, I did get to see the staff report that was prepared. And I just want to point out to some, what I think are inconsistencies in the staff report. And if you'll turn to it, you'll see at page 2 of the staff report, they talk about variance 1, the residential floor area. And they say that the increase the floor area ratio of the proposed dwelling from 29% to 33.91%. Well, that's what the bylaw is, 29%. But the starting point here is what's been approved already on the site, which, as I said, was 33.3%. So it's really only a 0.61% variance that we're seeking there. 115 square feet of which, by their own admission, is in the roof. And I say you won't see that. So I think And the rest of it, with respect to the text that's required under variance number 1, speaks to the established grade much higher. All of that already exists. None of that is being changed by this application. The house is going to be there. And they do point out that originally staff, way back in 2016, wrote a negative staff report, and it appears that all the same things have been carried forward to this report, even after committee has approved it previously. So none of those issues on the top of the second page of the staff report under variance number 1, nothing there is changing. Height of the building is not changing. The massing of the building isn't changing conceivably. You're not going to see any difference from the street. It's almost a hidden space. Same with the variance number 2, the front yard setback. You'll see that they reference the front yard setback from 10.13 meters to 5.06 meters. It's not. It's 6.47, I believe, that was approved. And that is what's there. And the difference is the fact that we're now covering the porch. So it now counts to 5.06. So it's 1.4 meters is the relief being sought here, the width of the front porch, because it's now covered. But nothing else has changed. He says they say the proposed front yard setback would have an adverse impact on the streetscape, noting it's correlated to additional floor area above the porch and additional area below, which counts towards lot coverage. That's an incorrect statement. Nothing's changing from the street. The only change you're going to see is the fact that you're now going to see these pillars and the cover over the front porch. That's all that's going to change from the public realm. Variance number 3 with respect to the lot coverage, I indicated to you that it's a total amount of lot coverage. It includes the rear pool pavilion. It speaks to, it goes up to 7.32 coverage. It counts in, there's a maximum of 5% in another portion of the bylaw. So you're not supposed to be any larger than 5, but you're counting it all in anyway. There's no exception for it in the bylaw as there are in other zones. That, to me, is a very minor increase of 2.32% for the functionality of the pool deck. I mean, if the building gets built as it is, from the rear, you're going to see the same glass panels. You won't know whether they're 2 feet to the deck or 4 feet from the edge of the pool. The perception you won't see. You're still going to see the same glass. So there's no difference there in my respectful submission. And with respect to the accessory building lot coverage in the 5 to the 7.3, they say the intent of the regulating lot coverage for accessory buildings is to ensure the structure is clearly subordinate to the principal use. There is no doubt that this pool area is a subordinate to the principal use in the property. Look at the building. It's a substantial building. The house itself, the total residential floor area in it is 6,000, just a little over 6,000 square feet. That's a big house. We know it's a big house. It's on the lake, and we have variances to build it. And when you look at it from the street, whether these variances are granted or not, it's still going to be a big house. There's a lake to the, I guess I always think it's to the south, but the lake is to the east here in this location. So the lakeside, there's no impact. The other side is a public park, which we've been through before. There's no impact there because the building is essentially going to look the same from that side. And on the other side of the public park, there's high-density residential. So you can see that in the distance. There'd be no impact there. And similarly, from Lakeshore, one of the reasons that the original variance was sought to the setback was because there was a widening taken of Lakeshore years ago to allow for the reconstruction of Lakeshore Road. So when you make that swing down and around Lakeshore as you're headed towards Brodie or towards Burl Oak Drive, there's a very, very large boulevard. So it appears and it seems that this house is set well back from Lakeshore, even though technically it's not, because the town acquired more land than I guess was necessary once the design was finished. In my respectful submission, this application before you is a minor variance application that meets the 4 tests, and it's desirable for the use of the property, and I don't see any impacts on the public at all arising out of these small variances. those are my submissions to you, and I'd ask you to approve the application that's before you.
Very well, thank you, Mr. Cheeseman. Questions? Go ahead.
Madam Chair, through you to the applicant, you've already come before the committee for variances. Why more of the same?
Explained.
Yeah, but.
We have a front porch that you can walk up to, this very large house.
Yeah.
To double doors. And my client, during the course of it, got the building permits, is ready to go, has made what I think is a reasonable request to say, you know what, I would really like to have a roof over it. That's the origin of the request. It's not, is it a need? There's no needs test. It's a question of, is it this, do you want it? And can you have it based on the 4 tests?
So then my next question is, so this has been in the works since 2016?
Oh, no,
Sorry,
this has been in the works since 2010,
Okay,
2011?
so then my question is, what's to say you're not going to come back and ask yet again for greater variances for this property?
Ma'am, the building permits have,
And then there's a cumulative effect.
the building, well, you can look at it cumulatively as well, ma'am, and I'm asking you to do that in this case. You look at the cumulative effects of these variances. Will there be more variances in the future? I suspect not. My client has spent a lot of time trying to get this house built, a single-family house on the lake to move his family into. He's been at it for a long time. He's near the finish line. He's looked at the design. It's being built, and he's basically said, can I make two small changes? Can I move the glass wall back a little bit from the edge of the pool, and can I put a cover over the top of the porch? And it results in certain variances. Agreed. We're here, we're seeking relief. If he comes forward with something else, they'd have to come and meet the 4 tests as well. But I mean, where my client is sitting tonight, this is the end of it all. He wants to get on with it. He's got his construction people out there. The house is getting built under the existing permits. If this gets granted, then there'll be design changes, and there'll have to be an alteration to the site plan that's been approved. So we'll have to go get that as well.
Thank you.
Any further items of clarification or questions? Mr. Talansky.
Thank you, Madam Chair. Yeah, Mr. Cheeseman, I accept your arguments that you're just trying to do incremental, but we gave you a 900 square foot variance. Like, when is big enough? When I drive.
Sir, you
you
gave me a 900 square foot variance, and you did. But that was part and parcel in mind of the fact that the bylaw that was coming into place, 2014-014, was under appeal by my client. And it was evaluated somewhat and that was the one that brought the O designation in. So when he started this process, the O designation wasn't there. So in terms of the way the variances got framed for purposes of settling out the proposal, the variances are what they are, and they are over what 2014-014 permitted. But it was done under the context of the 1984 bylaw. So to say that we did get a variance for what we're seeking.
The house
but
is
it's unclear
larger
that.
than the bylaw permitted it to be. We granted you
Yes,
a
absolutely.
variance for a larger house.
Yes.
Brought it forward. It's a big house.
It is a big house, sir, but not an unusually big house.
When I drove by the site,
Yes.
I was taken by the fact that my impression was the foundation, just the foundation seemed to be towering above the road and the adjacent property.
It's because the grade has been altered, sir, while the construction has been ongoing, right? That's all going to have to come back to the grades that have been addressed.
Your foundation's well above grade. Now you're going to put the house on top of it. Now you're asking us
No,
to
sir,
allow you to bring it even more forward and put a structure on top of it, making the mass even more opposing. How is that not going to cause a greater impact?
Well, sir, I believe that when you drove by the property, yes, it's under construction. There's been excavation. The foundations have been poured, but the grades are not the grades that you see. The final grades, that foundation is going to be buried. And that's contemplated by the building permit. The front porch that I'm asking to cover has been contemplated by the building permit. It's there. The difference is we're going to put a cover over it. Now, Mr. Hicks, in his design, didn't just put a flat piece of shingling over top of the front. He built something that fit into the pattern of the dwelling. That's that design thing. He's done it. Then it gets counted. Mr. Cosell has gone over it with a fine-tooth comb. Here's how he said, this is what gets triggered. That's all I'm applying for. At the end of the day, I want you to look at that and say, that's there. And that, I put it to you, that roof, the porch doesn't add to the massing from the street, sir. Once the grading and all the landscaping is put in, you won't notice a difference, sir.
I guess we'll disagree on that point.
I guess we'll see once the construction is finished and the grading is all in and the pictures are taken. I mean, at that point in time, I could come to you and say, look how nice it looks. I'd like to put a cover over it. And you'd get a different impression from it. And you'd look at it and say, you know, maybe there is no impact. But that would be prohibitively expensive to do because you'd have to change the entire front of the roof tie-in after the fact. So, I mean, there's a time to do it. This is the shot. You get one shot of it. It doesn't get done. It doesn't get done. You know, you're back to where you were.
Any further questions? I know Ms. Murray has a question of town staff. Go ahead.
Through you, Madam Chair, to town staff. Under variance number 2 and comments from the town, it says it should be noted that the applicant's previously approved front stairs and porch is increased in size, which includes an already poured foundation for an unapproved basement kitchen, formerly mechanical room, thus requiring additional relief from zoning bylaw. I don't see a variance requested for that. Are you indicating that we should see an additional variance, or that is against zoning bylaw?
No, through you, Madam Chair, simply what I was trying to demonstrate was that based on the floor plan, that kitchen itself was formerly a mechanical room and has been increased in size, thus requiring the variance to the zoning bylaw because that's where the setback is taken to. That's where the edge of the steps stops.
Okay.
And that's how it was explained to me.
Okay, thank you.
Mr. Cheeseman, you have something to say to that?
Well, yeah, just on that point, the building drawings that were reviewed were the building drawings that were reviewed by Mr. Cassell that brought us here today with the extra variances. The genesis of that, I'm told, is the roof structure. What's below ground doesn't change in terms of the way the walls, the interior walls change. It changes the room patterns, but it doesn't affect the GFA of the building. That was my understanding, and that's what. But the relief that we're seeking is the relief we need in order to pull the building permit. That's the most important thing. Whether I agree with it or I don't agree with it doesn't matter. What matters is, can I get a building permit from Mr. Cassell and the building department when I go to get him? If you give me the variances, otherwise they're of no use to me.
So the building permits you're operating with right now
Yeah.
are which ones?
The building are the approved building permits that are out that have been approved for the building, and what the changes that we're seeking. Those have been given to the town, they have been reviewed by Mr. Cassell, and they're the basis upon which these variances have been generated.
Okay.
You understand? So that this is what the town is telling us now is required in order to build the building that we'd like to build,
Okay.
with the front porch, et cetera.
Okay. Any further questions? Okay, if you have nothing further to add, Mr. Cheeseman, we will take the matter into committee.
Thank you.
I'll give you a moment. This is our last application of the night. I'll give you a moment to think, and then we can start the discussion process. discussion rolling? Okay, let's go for it.
Madam Chair, I'll put a motion on the table to get the discussion started. Madam Chair, my motion will be to deny variances 1 and 2, to amend variance 3 to permit a lot coverage of 27.29%, that on the advice of the applicant's agent that the front porch coverage was 0.63%, which you don't need that if the variance for the porch is not permitted, and to approve variance number 4. I'll start backwards. I'm satisfied there's no impact to the increased coverage of the accessory building, being given the location of the house on the lake adjacent to a park. Madam Chair, as I said to the applicant's agent, my perception of the building under construction is that it is going to be a large, very noticeable presence on the street. And I'm not convinced that allowing the front porch to come closer to the road and to have a massing on top of it is not going to cause an impact that, in my mind, that additional impact to what's already going to be a very large, prominent building. I just don't find that to be desirable. And so I can't support variance number 1. With that, you don't need variance number 2. And variance number 3 would be adjusted for the overall lot coverage to allow for the increased accessory building, but not allow for the increased coverage of the porch. On that basis, I find the revised variance 3 and variance 4 to meet the 4 tests of the Planning Act, but I don't believe variance 1 is desirable, and without variance 1, you don't need variance 2.
Okay. So, just so that I understand it correctly, variance 3 and 4 will remain the same without any amendments?
No, it would amend variance number 3 to reduce the overall lot coverage from 27.92 to 27.29.
29, okay, I didn't hear that, sorry.
What is in square meters?
And what is it? Oh, well, we have to calculate it. Just for discussion purposes, Mr. Hassan, are you following this so that Jasmina can get it right if we do approve this?
Through you, Madam Chair, I'm absolutely following and writing it down, but again, I don't have any way of confirming what the numbers would be. As you see in the site statistics, the proposed total coverage is 27.4. However, in the notice, it's noted as 27.92. So Mr. Cauzel uses an Adobe measurement software to calculate all of the areas. So that's how we get the precise lot coverages that are noted in the notice. So it's difficult for me to say and confirm what the numbers would actually be.
Okay, 27.
Yeah. Well, Madam Chair, I'm basing it based on the information on the application given by the applicant's agent, and I guess I would also add, which I didn't, that I'd make that amended approval subject to development proceeding in general accordance with site plan and elevations to the satisfaction of the Director of Planning, and that additional building permit issue within 2 years.
Okay, very well. So that, Mr. Hassan, that would cover those issues, correct?
Through you, Madam Chair, it would cover the proposed changes, but again, if there's a discrepancy in the numbers, that may cause an issue for zoning staff, just purely based on their review and their ability to sign off.
But if it's to the satisfaction of the Director of Planning, then
If
No?
no, through you, Madam Chair, if it's less than the 27.29, I believe is what Mr. Talansky had said, that would be fine. But if it's above that, that would be an issue. But through the, I guess, review of the Director of Planning Services, I guess adjustments could be made by the applicant to reduce it below the 27.92 that Mr. Talansky has indicated. So it's a fine line, unfortunately.
how do we feel about that in terms of the discussion?
Uh,
Mr. Hardcastle, go ahead.
Thank you, Madam Chair. I agree with the comments of of Mr. Talansky. I think this is an imposing house. I think being out on site demonstrated, and I don't agree with the proposition that was put forward by Mr. Cheeseman with respect to grading changes and alterations. This is a largely exposed foundation, particularly from the park side and from the interior side lot line. And really the grading changes are minimal in the front yard to slope up towards the front door. So the imposing nature of this is considerable in swaying my opinion about the appropriateness of the additional RFA. In terms of the adjustments to the pool pavilion, I agree again that they'll have minimal impacts to anything on hand. So I would support the motion, and in terms of the accuracy of the information, if it's not adequate for the applicant's needs, then we can see him here again to refine the numbers if it doesn't work out. That's my thought, so I'll be supporting the motion on the floor.
Very well. Any further comments or to this discussion before we vote on the motion? Okay, so the motion before us is to eliminate or deny variance 1 and 2, and then approve variance 3 and 4, subject to the amendment that the lot coverage will be at 27.29%. We're gonna leave the square meters out. You'll put them in as necessary. Yes, correct, Mr. Talansky, 27.29%, based on the applicant's numbers from their, what do you call that? Grid figure. Yeah. Okay. And then subject to the conditions, as Mr. Talansky said, that it's subject to the drawings and elevations submitted with the application, as well as to the satisfaction of the Director of Planning. Did I cover it all?
Through you, Madam Chair, as Mr. Cheeseman had noted, if the approval proceeds in that fashion, there would have to be an amendment to the site plan application as well.
Okay, so how would we word that? I'm just covering my bases. I don't know how they're gonna vote yet. I just wanna cover my bases before we vote so that everyone understands what we're voting on.
Right. I don't have the exact wording, but it has been done in the past. The most recent one I can remember was 331 Shedden Drive. There was a minor variance that was applied for after site plan approval was granted. It's just simply a note in the file, like for red line drawings.
Okay. Give me something for Jasmina to write.
That the applicant receive approval of a note to amend the site plan application.
Okay, subject to the amendment of the site plan applications as well.
You can put to the satisfaction of the Director of Planning Services.
Okay. Yeah. Subject to site plan, what did I just say? Revision or alterations, subject to the satisfaction of the Director of Planning as well. Does that cover it?
Sorry, through you, Madam Chair, Jasmine, are you able to read it back to me?
Yeah, just read it. Read it back after your.
Revised site plan and elevation drawing be with the satisfaction of the Director of Planning Services.
Yeah, through you, Madam Chair, as long as it notes that there's to be an amendment there for the file, that would be correct.
Yeah, and there's an amendment to the site plan application, right?
Well, it'd be the previously approved site plan.
The
Yeah.
approved site plan, subject to the amendment of the approved site plan. Okay. All right, let's vote, and then while Jasmina figures out the wording, but just in case. All those in support of this motion? Okay. Everyone approves this motion? Okay, now you have the words.
Yeah,
Okay, very well. All right, so the motion has been approved, and now we have minutes to confirm for February 18th. Who would like to move the minutes? Mr. Flemington has moved the minutes, and who would like to move a motion to adjourn at, Ms. Murray, at 9:01 p.m.? Okay,